Good afternoon, everybody. Thank you for attending today's session on housing discrimination, common complaints, and criminal backgrounds. Just a couple of reminders before we get started. Please make sure your microphone and your cameras are off to reduce distraction. If you have questions, please type them in the chat box and I will relay them to our presenter as we go along. At the end of today's presentation, there will be a survey sent out. Please provide any feedback and possible topics you would like seen presented on for our next session. So with that, I will turn it over to Kirsten.
Thanks, Kylie. My name is Kirsten Small, and I am an investigator with the North Dakota Department of Labor and Human Rights. I have been with the department just over 10 years now. I've done a lot of different types of investigations, a lot of wage and hour complaint investigations, a lot of discrimination investigations in employment and housing, public service, public accommodation. So been kind of all areas of the department, hopefully provide you guys some good information kind of about what the department does, what kind of issues that we handle, and then talk a little bit about some of those housing-based, how criminal background checks can be handled, some of those common complaints we see, and just give you guys a little bit more information, again, specifically related to what the department handles with regards to housing discrimination. So first off, we're going to talk a little bit about the case process. So we're going to talk a little bit about what the department does. We're going to talk about what does an investigation with the department look like. We'll kind of be a little bit more brief on this. I usually go a little bit more in depth, kind of in the longer 2-hour presentation, but we'll just give you an overview and an idea of what it is that the department handles because it sets up a little bit better on kind of how we investigate these types of issues and what happens when we have any sort of allegations come through of discrimination specifically for housing. We'll go over some common complaints. I will tell you from doing this for quite a while, there is no such thing as a common complaint. Every complaint is so vastly different in the fact that it's so case specific, it's so fact specific, but there are some kind of commonalities of things that we see continuously happening as far as violations or kind of common missteps or issues that happen within the for example, interactive process, reasonable accommodations, or in discriminatory statements, that type of thing. So we'll talk a little bit about what those common complaints are that we see at the department. Then we'll talk a little bit about criminal background checks, kind of how they are used and things to watch out for specifically in relation to housing discrimination. And then we'll have some time at the end for any sort of questions that you have. But as Kylie mentioned, if you guys have those as we go along, type them in the chat. I'm usually pretty informal as we go through this. So if the questions are piling up, we'll kind of go through them at the time of and just work through those. But like I said, we'll also have a time at the end for any of those questions you have. So before I started at the department, I just assumed the department was always a pretty small department. It was kind of a surprise to me to find out that we have only 7 investigators for the entire state of North Dakota. We handle all of the issues related to wage and hour. So if employees believe they have not been paid properly, if they think that there's deductions that have been made from their check, if there's 14 and 15-year-old employees, they have certain work parameters that they can kind of work hours they can only follow, kind of job duties that they can follow. We handle those. We handle issues with relation to independent contractors. So that's kind of our one pillar, which is that wage and hour division. We also handle the human rights division, which is the discrimination side of things. So we handle discrimination in employment, housing, public service, public accommodations, and credit transactions. Of that list, the discrimination in employment by far the issue that we see the most in. We'll kind of talk a little bit numbers wise, but we see over probably 80% of our complaints are related to employment discrimination versus the other categories. But following behind that would be the housing discrimination. It's probably our second most filed on issue under the human rights side of things. And then the kind of our third pillar, our third basis that we handle, we always do a lot of public outreach. So we do education and awareness. Basically, this is to hopefully prevent issues from happening in the first place. We are a neutral enforcement agency. And what that means is we just enforce the laws. We're not on the claimant's behalf. We're not on the respondent's behalf. We are solely there to evaluate facts and information and determine if a violation of the law occurred. But again, being that we're that neutral agency, we're kind of that middleman, it's always in our best interest to also provide good information to the public, whether that's for employees receiving our information or tenants receiving our information, or on the flip side, respondents or employers that are receiving our information. So we do a lot of different presentations, booths, that type of thing to kind of expand knowledge of what it is that our department handles. So under the human rights side of things, like I said, this is the discrimination umbrella. So under that umbrella, we handle four major pieces of the law. The top two on this list are going to be related to discrimination complaints, and then the bottom two are more specifically for retaliation. And I'll explain a little bit between those differences. So the Human Rights Act, that's going to be kind of the all-encompassing handling of employment discrimination, public service, public accommodation, and credit transaction. It's kind of a very broad area that covers a lot of different aspects. It does have retaliation provisions under this law, but it's specifically for individuals that have reported discrimination in some way, and then as a result of that, they were discriminated or retaliated against, rather. So, for example, if an individual they report sexual harassment in the workplace. And as a result of that, their employer terminates their employment because they had reported that sexual harassment. That's a retaliation that'll fall under that Human Rights Act. The North Dakota Housing Discrimination Act, that's the one we're going to be talking about the most today, but it's pretty self-explanatory. It's related to discrimination in housing. This too, kind of like the Human Rights Act, has a retaliation provision in it that if an individual opposes some kind of discriminatory act in their housing situation, maybe they requested a reasonable accommodation or a reasonable modification. And because they did so, the respondent took some sort of retaliatory action against them, that's going to be a retaliation provision that's under that North Dakota Housing Discrimination Act. The other two, those are related to solely retaliation, specifically if an individual believes that there's some sort of law violation occurring or they're being asked to do something that they believe is a violation of the law, they report it, and as a result of that report, they're retaliated against. That's what that whistleblower and then that Public Employees Relation Act, that's both of those cover those aspects. Biggest difference is the North Dakota Public Employee Relations Act obviously is for public employees, and it's pretty specific on how those individuals report something in order for it to be a retaliation complaint. So again, the issue we're going to be talking about the most today is the North Dakota Housing Discrimination Act. Kind of hand in hand with that is the federal side of things, which is the Fair Housing Act of 1968. So when you think of kind of the all-encompassing fair housing laws, the Fair Housing Act is probably the one that you're going to think of the most. That one, like I said, is the federal side of things. Generally, it's enforced by HUD, which is, again, the federal side of things, the Housing and Urban Development. But basically, we have a partnership with HUD where we can investigate cases for them and they can investigate cases for us. We do have to have our laws be what they call substantially equivalent, which means that basically we can't have any laws that contradict the federal law, or we can't have any laws that the way that they would be enforced would not allow the Fair Housing Act, the actual federal law, to kind of move forward. And so with that partnership, we investigate cases under both laws. So even though there's a federal law and a state law, we are able to do one investigation under both sets of laws, as opposed to in some states and some, even in the past, it has been that those two laws can be separated. And then what happens happens is if a Housing Discrimination Act is alleged, then HUD could come in and do their investigation. And then we as a department would come in and do our investigation under the state law. So it was two investigations for one set of issues. So that's why we kind of have that substantial equivalency. It's also why during legislative sessions, if you hear of some concerns or changes where the department might be speaking up on behalf of, on certain sides of changes to the laws. Specifically, we've seen it with assistance animals. Sometimes we are trying to discuss the concerns that if the change was made, then we would lose that substantial equivalency. And then there would be, like I said, two separate investigations that would occur. Also with that partnership, our office does basically get funds through the federal government to perform those investigations. So obviously would be a substantial change to our budget if we didn't have that substantial equivalency. So what do the fair housing laws do? Just kind of as a broad definition, it makes it unlawful to treat someone differently in that sale or rental of housing because of that person's membership in a protected category. You'll hear me say it quite a bit throughout this process, protected category. So what do we mean when we're talking about a protected category? These are the protected categories. We're talking about race, color, sex, pregnancy, religion, national origin, familial status, domestic violence, and disability. We do have kind of the federal laws, which we have to have coverages under, but we also have additional laws that the state can have. Kind of you have to have the bare minimum, which is what the federal law requires, but you can have above and beyond provisions that cover additional coverages. So in our state, we do have the additional coverages of age. So if you believe you were discriminated against in housing because you're age 40 and over, you can file a complaint with our office. The receipt of public assistance. So this would be if an individual receives maybe rental assistance or some sort of financial assistance in some capacity or any sort of public assistance, they can file a complaint that they've been discriminated against because of their receipt of that public assistance. And then we also have marital status and domestic violence. So marital status, they could be discriminated against because they are married. They could be discriminated against because they're divorced. They could be discriminated against because they're separated or single. So that marital status is an additional category that we have within the state. And then the domestic violence is the newest protected category that we do have on the state side of things. And it's a very kind of limited scope on who falls under that category, but it's individuals who are victims of domestic violence that are part of a state-funded program. There's protections for them within the state. So these are those protected categories. So if anybody is discriminating against somebody based on one of these categories, then they would have a right to file with our department. So talking a little bit about what the role of the department is for an investigator. Our role is to conduct a fair and impartial, thorough investigation into the facts and circumstances of the complaint. So ultimately what we're doing is gathering the information, documentation. It can be witness interviews, it can be documents, it can be just general information. But ultimately we're determining, is there reasonable cause to believe that the respondent committed an unlawful act of housing discrimination or not? So that's what the entirety of the housing process is looking at. When it comes to the complaints, and we'll talk about this on the next slide here, of when we receive the complaints, we're looking at whether or not we have jurisdiction kind of on the surface. So it's based on what the allegations are of, if the allegations are there that, hey, if this is true, this could constitute a violation of the law. Generally speaking, that's going to be enough to file the complaint. So let's talk a little bit about what the process looks like. So for the this goes for the wage and hour division as well as for the human rights division. But basically, the first thing that we do is somebody has to file an intake with our department. So they have to file a form saying, I believe XYZ occurred. So I believe I was discriminated against, and this is the reason why. Or I believe I was retaliated against, and this is the reason why. That first point of the process is that intake, and it's just notifying the department that these allegations exist. And so then once we receive that intake form, it's our job to evaluate that information and determine, do we have jurisdiction over the complaint? So did the allegations occur within the 1 year statute of limitations? So there's different statute of limitations for every issue. So for wage and hour complaints, it's 2 years. For discrimination in employment complaints, it's 300 days. But for housing complaints, it's 1 year from the last date of harm. So if something happened to me yesterday, I have until 1 year from yesterday to be able to file a complaint. It can get a little bit hairy if, let's say, it's getting really close to that statute of limitations. It's from when the actual action happened. So it might not necessarily be, when they were notified of something happening. It could be that this is when the actual action took place, or maybe it is when they were just notified, even though the actual action didn't occur for another week or two. So it's something, if you are kind of holding out, seeing if you, or deciding if you want to file, sometimes it can be best just to make sure you get the complaint in and make sure that we're able to evaluate that jurisdictional part, because you don't want to, realize that you were a day or two late, because unfortunately, with the statute of limitations, there's really no flexibility with that. But like I said, we're looking at that jurisdiction piece of it. As we look at that jurisdiction piece of it, obviously statute of limitations is kind of a major one. Whether or not the respondent is somebody we have authority over, or the allegations are something we have authority over, that's going to be a big piece of it. But one of the other things that we look at specifically with housing is there what we call a nexus or a connection between what the allegations are and the discriminatory action? So anybody could come to our department and say, well, I'm being evicted. I think it's because I have a family. And that certainly can be an allegation in and of itself, but why do you believe that it's based on the fact you have a family? Are there other families in the building? Have other families received eviction notices or not? Have there been other actions that indicate it was based on a protected category? Some of that background information is something that's important to look at, to have that connection or nexus between what's being alleged. So that's one of the pieces that we look at. If we determine, yes, based on what's being alleged, there's enough there for us to at least write the complaint. And again, that doesn't necessarily mean the department believes that a violation did or did not occur. It just means that based on what you've alleged, that's enough for us to move forward with filing the complaint. And when we do that, we are going to be putting together the complaint in a summary. So sometimes we will have complainants provide us 20 or 30 pages worth of documentation and information and timelines, but maybe the complaint itself is only 3 pages long. It's because we are only looking at the specific allegations, and some of the information that's provided may be background information. It may be information that's definitely going to be helpful for the investigation, but it's something that's not necessarily relevant to have on the complaint itself. And so we do want that short and concise statement indicating what is being alleged. And then that is sent on to the respondent. So once the complainant signs that complaint, that officially opens it, then we send it on to the respondent and say, hey, this is what Sally's allegations are, please provide a response to those. And then the respondent would provide their side of it. They'd provide any and all documentation that they have in support of it. And then once we receive that response, that's when the investigation starts. So that's when the investigator will be seeking out additional information. They'll be going through interviews with the parties to understand the complaint better, basically just getting into it to determine ultimately if there's reasonable cause to believe a violation of the law occurred or not. And so that's kind of that final step in the process, is for us to issue out that determination. And that's just a written report of our findings. Ultimately, we are determining if a violation of the law did or did not occur. So if we believe, yes, there is reasonable cause to believe a violation of the law did occur, then we issue out a charge. So it's just a short and concise statement of the facts, determining that we believe, based on what had occurred and what was alleged and what the documentation showed, we believe a violation occurred. If we do not believe a violation of the law occurred, then the case would be closed with our department. We don't have any specific appeals process. Obviously, we will evaluate information if there's new or additional information being provided, but we will not reopen the case to kind of reevaluate it and look into it again just because one of the parties is disagreeing with our findings. The recourse for any party really is court at that point. Conciliation is something that's always going to be emphasized throughout the process. So the conciliation process is just trying to resolve the issues prior to the completion of an investigation. Basically, is back and forth offers. Sometimes in these cases, a very simple, a positive rental referral, or maybe it's just allowing them to be released from their lease. Maybe it's paying a certain deposit or something of the sort, or forgiving a deposit, things like that. So conciliation really can be endless options. I always laugh because doing this long enough, I've really thought that you might be able to see most of what could be offers or resolutions between parties. And every single time there's still new offers or kind of ideas of resolutions that I had never seen before. So really the options are kind of limitless, but it's something to try to resolve the issues between the parties prior to the point of an investigation. So we do have our upcoming biennium report here due in December. So this is the last biennium kind of official report numbers. And I also included the biennium previous to it just for kind of numbers sake, but we had 19 cases that were resolved through conciliation or through that kind of informal resolution process. We had 13 that were no reasonable cause, which means that we do not believe a violation of the law occurred. 4 that were reasonable cause, so we had reasonable cause to believe a violation did occur. 4 of the cases were dismissed. Could be for various reasons, but pretty much the main reason a lot of cases are dismissed usually is because the complainant kind of falls off the face of the planet. If we're unable to reach out to them, we have a very formal process of, you have to make so many attempts, you have to make it during certain times of day, in certain different methods, but if we're still unable to receive any sort of correspondence from the complainant, we would have to close the complaint and dismiss it. So that's usually the reason why a complaint would be dismissed. We didn't have any that were referred to HUD, but we can have cases if it's, let's say they have a number of complaints of a certain type and they're requesting those to be sent to HUD, or maybe they have a certain number of cases that are all from the same complainant or the same respondent. Maybe HUD would request those. So sometimes they could be referred to HUD, but we didn't have any really in the last 2 bienniums. And then we had 4 that were withdrawn with resolution, 2 withdrawn without resolution. These are kind of like conciliation sometimes, but they're just more informal where, hey, we filed this complaint, but the respondent and I were able to work it out. So we did come to some sort of resolution on our own. That could be withdrawn with resolution. Withdrawn without resolution, maybe the party moved to a different apartment and said, you know what, I don't have time for this, or I don't want to deal with this. I'm just going to let it go. I don't want to handle the case moving forward. Maybe they withdraw it even though a resolution wasn't reached. So now we'll talk a little bit about those common complaints. Like I said, there's no such thing as a common complaint just because it is so fact and case specific, but there are some general items and issues that we see kind of perpetually filed on. So we'll talk a little bit about those. So in that last biennium of the cases, kind of how they were filed, so what basis they were filed on, by far the highest number is based on disability. And of those 28 claims of disability, 24 of them were reasonable accommodation. So we'll talk a little bit about reasonable accommodation because that is one we see over and over and over again. We do see a handful of retaliation. We'll talk a little bit about that as well as public assistance. But really, as you can see, numbers wise, everything else is not even, a drop in the bucket in comparison to those disability related claims. So what exactly is disability? For our purposes, we have to look at that Fair Housing Act and then that North Dakota Century Code 1402.5, which is that North Dakota Human Rights Act, or Housing Discrimination Act, rather. So when we're looking at it, we're looking at the individual has to have a physical or mental impairment that substantially limits a major life activity, or they have to have a record or a history of such impairment, or is regarded as having such an impairment. So maybe they don't have the actual impairment, but they're being regarded as if they did. This is going to be a very fact and case specific inquiry. There's going to be people that, maybe they have been considered disabled under SSDI. Maybe they are considered disabled to a certain degree under their veterans benefits. That is not going to be the same analysis. So we look at it specifically only with regard to this law. And there's obviously factors that can play into it. How substantially limited are they? Are there any mitigating measures as far as like medication or braces or something like that limits that major life activity issue? So all of those things is what plays into that disability analysis. When we're looking at a housing entity as a whole, so we're looking at who or what's going to be covered. When somebody comes to our department and wants to file a complaint, we have to look at are the aggrieved people, are they a member of a protected class? Are they alleging allegations that are based on that protected class? But is the dwelling or the housing related transaction covered under the law? So we're looking at those rentals, sales, and other types of transactions. Is it housing related? Most of the time it's going to be. It's not too often that complainants will file and not realize that it really wasn't housing related. Generally, they know which form, or we'll make sure that it goes to the right form depending on what their allegations are. The other piece of it is the respondent covered under the law? So there are some exemptions from the law itself with relation to housing discrimination. There's some exemptions for the size of home. So if it's they call it a Mrs. Murphy's exemption. So if there's 4 or fewer units and one of the units is occupied by the owner, that's not going to be something that's covered under the fair housing laws. Is it a religious organization, or certain private clubs are going to be exempted from the laws? So we have to look at that as well. Again, under those issues of disability, of those 28 claims, 24 of them were reasonable accommodations. So we'll touch base a little bit on this. We'll talk a little bit more when I get to kind of the broad overview of those common complaints. But reasonable accommodations, it's just a change, exception, or adjustment to a rule, policy, practice, or service. Basically, they're asking for an exception to the rules. So if there's a no pets policy in the building and they're requesting an emotional support animal, they're asking for an exception to the no pets policy for something related to their disability. So the fair housing laws do require reasonable accommodations for individuals with a disability, and failure to do so constitutes discrimination on the basis of disability. Basically, it's going to be something that kind of levels the playing field so that they can enjoy the property in the same way, regardless of their disability. So think of it, even though sometimes it's hard to think, well, how is this something that helps them enjoy the property. It could be something like, hey, I'm not able to take my rent check to the mailbox that you're requesting, but I can mail it into you. That's an exception to a policy or a practice. It's just something that's going to be there to help have the enjoyments, the same enjoyments for the individual, regardless of their disability related status. Reasonable modifications, kind of similar to reasonable accommodations, but these are those structural changes. So this might be adding a ramp. It might be something like lowering the countertops, making some of those physical adjustments to the property. They are a little bit different than reasonable accommodations because, as you can see here, the reasonable accommodations is much more to those rules, policies, and practices, and the modifications obviously are those physical barriers. But when it comes to reasonable modifications, generally speaking, the costs are going to have to be paid for by the tenant. There are exceptions to that for certain federally supported programs. Then they may have to be covered by the landlord. But in a lot of circumstances where there's not that federal supported program in place, then the tenant would be the one that would have to pay for those repairs. Additionally, they may have to kind of put the property back into its original form if they were to leave the property. So those are some kind of things to keep in mind when it comes to those reasonable modifications. But of issues that we see at the department, by far we see more related to reasonable accommodations as opposed to those modifications. When we're looking at those reasonable issues, so we're talking about reasonable accommodation, a reasonable modification, we're looking at, does it constitute some sort of undue hardship? So if the change or the modification, whether it's to a policy or to the building itself, is it something that's going to impose some sort of financial or administrative burden? Are they going to have to hire new staff in order to put this in place? If they are, a one apartment building and this change is going to cause millions of dollars of financial impact, is that going to cause some sort of financial undue burden? Then that's going to be something that we would look at. We're going to also look at, does it change the fundamental operations of the business? So that's going to be something that it may be unreasonable at that point. Even if it is unreasonable under the law, there may still be an obligation for a landlord to still make those accommodations or modifications. They may not be the ones that are requested, but they still have to be effective. So they could potentially offer other reasonable accommodations or modifications in lieu of what the requested item was. So service and assistance animals, this is one we see by far the most when it comes to kind of common complaints, whether it's just complaints that we receive at the department or actual cases that go all the way through investigation. Service and assistance animals are different than pets. We have a lot of landlords that will say, well, I have a no pet building. The request for a reasonable accommodation for an assistance animal or service animal is going to be different than requesting, hey, I'd like to have my pet there. The way to kind of think of it is it's similar to if an individual needs a wheelchair in order to maneuver around the apartment or just for their disability as a whole, and a service or assistance animal may be in this kind of same realm. It's something that is providing that benefit, that enjoyment of the property because of their disability. And so it kind of the same assessment. To deny that accommodation, the landlord must prove that the accommodation is not reasonable, not necessary, or causes some sort of undue burden to the landlord. So we see a lot of issues with the service and assistance animals. And we actually honestly see them on both sides of it. Sometimes the landlord asks for additional documentation, which in some circumstances it's absolutely permitted. And if the tenant does not provide that information or doesn't provide clarification to the request, then that could be that they drop the ball. And even though the respondent again has an obligation to handle requests, if they've made requests of the tenant to provide additional information and they refuse to do so, it could be the failure of that interactive process on the tenant's behalf. So there can be a variety of different types of assistance animals. It's not always going to just be dogs or cats. Service animals are specific types of animals, but assistance animals, emotional support animals, that type of thing, really can be a wide range of different types of animals. These are kind of really within the last few weeks changes. HUD used to have a notice and a joint statement that kind of indicated pieces to what you should assess when you're looking at reasonable accommodations. They have since pulled that guidance. They basically have decided to have they don't have the guidance or the joint statements out because they've decided that it'll be more of a case by case basis and assess it as opposed to kind of broad overarching guidance. And so they no longer have that guidance out there. But in the past, they've really looked at things like pet fees or additional security deposits that they cannot be imposed if it's a service or assistance animal. So basically, they can't have that as a condition of receiving the reasonable accommodation. For example, if you have an individual who moves into the apartment, requests that reasonable accommodation to have the animal, even though you may have a pet deposit, this is not a pet. So to impose an additional fee just as a condition of the accommodation may not be legal. Some of the other issues that we see with relation to service and assistance animals, we get the concerns of it's a direct threat or there's city restrictions. We saw this a lot when there were the breed restrictions in a number of cities. And the issue with that is there can certainly be breed restrictions within a city, and the landlord likely is not acting out of ill will to not provide a reasonable accommodation. But if they are not providing the accommodation because it's a quote unquote dangerous breed or it's a certain type of breed that the city doesn't allow, the tenant can make a complaint against the city themselves if there's no provisions for reasonable accommodation exceptions. And so just because it is a city-wide ban or restriction on the certain type of animal, the landlord may not necessarily have a justified cause of saying, well, I'm denying it because it's not allowed within the city. That may be an issue that the tenant has with the city, but the landlord may not necessarily be able to use that as a reason to deny a request. There might be a need for the animal to enter common areas. Just because the reasonable accommodation is obviously for that individual to enjoy the property, they may need to have the use of that animal in common areas. There might be those requirements of you have to spay and neuter the animal, you have to have certain breed restrictions, weight limitations, it has to be a small dog, it has to, be a certain type of breed, or it cannot be a certain breed. Again, kind of like those pet deposits, you can have impose those additional provisions as a condition of receiving that accommodation. So just to have those limitations out there, they may not necessarily be permissive for a service or an assistance animal. That being said, landlords absolutely can have expectations of behavior. So they can have expectations of you have to clean up after the animal, you have to maintain control over the animal, you can't let the animal, roam free, and maybe it has to be on a leash. You can have absolute behavioral expectations of the animal and uphold those, even if it's a service or an assistance animal. So kind of along those same lines, we see a lot of issues with the pets aren't being picked up after. Again, that's a behavioral expectation piece. You can absolutely have those expectations of your tenants that yes, you need to have, you need to clean up after the animal. We've seen complaints with late rent due to SSDI payments. So let's say their SSDI payment doesn't come in until a certain point in the month. And so they're requesting a reasonable accommodation for the payment to be basically their rent to be late, the payment to be accepted later on. The big thing with that what our department looks at is the request medically necessary? So is it going to be directly tied to their disability? Those are things that we would look at, and it certainly may be. There may be justifiable reasons behind it, but when it comes to those reasonable accommodations, that's something that we look at is there a medical necessity for it? What is that medical tie to the requested accommodation? And so something like that, it may not necessarily have that medical tie to it. Too many animals in the unit or those uncommon pets. If the individual has a disability and let's say they need to have 5 rabbits, and all of the rabbits provide certain aspects to this individual's disability, and their medical provider has confirmed, yes, they're a person with a disability. Yes, they are in need of the 5 rabbits, the 5 various rabbits to accommodate for their disability. That could be enough to indicate, yes, even though you don't necessarily want 5 animals in the unit, that may be something that they need for their disability. And unless it's one of those undue hardships or that unreasonable nature of it, you may have to permit that, especially if they have that medical documentation. Where we see some problems with that sometimes is maybe the individual has 5 rabbits, but they just have a medical note saying they are in need of an assistance animal. The landlord could actually absolutely ask, okay, so what is the need for the 5? Do you need to have all 5 of these animals? Or, is this medical note meaning only one? Because it's not clear. It's not indicating in that note. But if it is clear, there absolutely may be a requirement that you permit those animals, even though, you may think in your head, well, why would they need all 5 of these? If their medical provider confirms, yes, they need all of those, they may certainly need them. Scented products used in hallways. Maybe it's that common area space and you're using certain cleaning products. Some people, especially with breathing conditions, COPD, asthma, that type of thing, maybe they have trouble breathing with any of those heavily scented products. So their request for an accommodation could be, I'm requesting you to use lesser scented products or a certain brand of product that doesn't irritate my disability. Those could be some common issues that we see. So can requests be denied? Absolutely. As we kind of talked about, if they have that undue hardship, if they have that unreasonable nature to it, absolutely they can request or they can deny any request. Again, they're going to have to look at it closely. Were there alternative accommodations that could have changed things? We see a lot of kind of missteps in that process of, well, it just seemed unreasonable, but not really exploring any other options certainly can be a problem. Another question, can a landlord ask for documentation related to a disability? It's something that's kind of a towing on the line all the time. A lot of people will get nervous about what they can and can't ask for. Should they ask for more? The short answer is maybe. You can certainly ask for additional information. Like I said, if it's not clear, if it's kind of one of those special circumstances and the documentation you have is not clear, does not show one way or another, then absolutely there may be issues that you would need to ask for additional documentation. So if the documentation received for an accommodation request is not clear, you may ask for additional documentation that verifies that the presence of the disability and or that specific connection. That being said, you're not the doctor, you're not the medical provider. If it makes that clear of the disability related need for the accommodation, that's generally going to be enough. Sometimes we have landlords that say, hey, I didn't ever get any sort of confirmation of what their disability is. That's not going to be something that you can request additional documentation on. Discriminatory statements. This one is one we see a lot of issues with. With regards to the law itself, it just states that a person may not make, print, or publish or affect the making, printing, or publishing of a notice, statement, or advertisement that's about the sale or rental of a dwelling that indicates any preference, limitation, or discrimination, or the intention to make a preference, limitation, or discrimination because of one of those protected categories. So This one we see a lot. It may not always be ill-intentioned. It could be that you're very well-intentioned in the statement you're making, but it may not necessarily be legal. A lot of times we see it on situations where, hey, I was in a bad situation before. I'm not going to rent to those single bachelors again. They really caused a lot of problems. I'm not going to allow assistance animals anymore in my building because they really have caused me problems in the past. Those discriminatory statements certainly can be indicating a limitation or a preference, again, based on one of those protected categories. So big ones that we usually see it with is public assistance. We see it a lot with familial status. Those families are too noisy, is bothering other tenants. Maybe marital status, only wanting married couples because bachelors are problems. We see a lot of those issues, even with relation to disability, stating other tenants' dogs are at least paying a deposit. They may not necessarily, again, be something that, boy, I was looking to discriminate against somebody. It could be just statements you're making based on those previous interactions or issues that you've had. So are background checks legal? Yes. Background checks are a unique thing because we in North Dakota do not have a protected category related to any sort of criminal backgrounds, whether it be in employment or in housing. We don't have specific protections with our department related to criminal backgrounds. The one thing that we see a lot with criminal backgrounds is, does it have a disparate impact? So basically, is it unfairly treating individuals of a certain protected class differently because of the use of those criminal background checks? We see this a lot more, I would say, nationally, and this is why I kind of put the statistics for the United States as well as for North Dakota. But there's certain populations that kind of have a higher percentage in the general population of having criminal backgrounds, being within the prison system. And so that is where that disparate impact can occur, because let's say you run background checks and you say absolutely no one with any sort of criminal background. You may not necessarily be intending to limit individuals who are of a certain race, but they are disproportionately in the prison population. So it could inadvertently have that impact of treating individuals differently, specifically on the basis of race, even though you may universally be using background checks across the board. Having those specific limitations can certainly kind of alienate certain groups of people. Things that you really should keep in mind and look at when you're doing criminal background checks is looking at them on a case-by-case basis. So assess the conviction and the situation on a case-by-case basis. Look at the nature of the conviction. So what was it? When was it? Was it something like an unpaid traffic ticket, or was it something much bigger? Is it something that's potentially going to cause some sort of impact within the apartment community or the rental community? The gravity of the conviction. So how severe was the conviction? Like I said, kind of the traffic ticket versus something else. The time elapsed. So did the individual, were they arrested for something when they were 17 years old? They served 10 years, got out, and they are now 65 or 66. That's going to be a great deal of time between whenever the conviction occurred and maybe when they are seeking any sort of rental housing. So looking at that kind of time elapsed between is certainly something to take into account as well. And again, looking at the context of the housing situation. Is it a is it a single family home that they're not necessarily around other individuals, or is it an apartment building that has a great deal of other tenants, and you maybe have some viable concern as to why the individual with that certain conviction be assessed differently? When we look at whether something has a discriminatory effect, there's kind of a three-step process that HUD looks at, and they state that the plaintiff must prove the policy has that discriminatory effect. The burden shifts to the housing provider to prove the policy or practice is justified. And then we also look at, is there a less discriminatory alternative? So when we're looking at that, we're looking at the challenge practice. Does it actually or predictably result in some sort of disparate impact? So, like I said, with these issues related to background checks, we're looking at, did they have something that would have a racial or ethnic disparity? Again, when it comes to criminal background checks, looking at it on that case by case basis is going to be your best practice because of kind of how these factors can impact the decisions. So that second step of that burden shifting to the respondent. So the respondent interests, they can't be hypothetical or speculative. So they can't say, well, we have to run the background check and nobody with this conviction can come, because what if they would attack somebody? Or what if they would, be in the wrong situation? So those hypothetical situations, whether it be for direct threat with a reasonable accommodation or other circumstances, hypothetical, that kind of crystal ball is not going to usually go very well as a defense. So again, reliable evidence to show the policy or practice assists in protecting the resident's safety and or the property. And again, policy or practice must consider the nature, severity, recency of that criminal conduct. And then again, is there any sort of less discriminatory alternative? So if again, that individualized assessment is going to be best. Really, when I talk about it, and I have it on a later slide, but looking at the other factors, does the person even qualify for the property as a whole? Do they even make the income requirements? Do they make the rental reference requirements? Look at those things first before going down the path of that criminal background. There are some exemptions from the criminal background piece to it. The illegal manufacture or distribution of a controlled substance is an exemption within the housing requirements for criminal background checks. But the biggest thing with this is it has to apply to the conviction as opposed to just who is arrested for the offense. So if they have not been charged yet, or they were arrested but never were charged, the conviction is what's going to matter in that piece. So again, kind of best practices on HUD side of things is make sure you have a narrowly tailored written policy. So make sure that you're really assessing these specifically for, if it's going to be certain offenses, making sure that it's within the context of what is that housing situation? How is this actually protecting our residents? Really understanding the justification for the policy and having that consistency within it, and train those managers and decision makers on how to implement the policy that is consistent with making sure that you're not discriminating against certain types of people. Again, just really delaying that consideration of the criminal history until after the other factors come up can certainly prevent a lot of these concerns or issues as well, because maybe they don't even qualify for the property, in which case going down the path of the criminal background check is not necessary. So biggest things to keep in mind, really understanding the obligations under the reasonable accommodation statutes. That's the one we see the most issues with, we see the most complaints with, and the most missteps with. So really understanding what you can and can't say with regards to reasonable accommodations, what you can ask for, kind of looking at those individualized situations, case by case basis will always be helpful. Knowing the law. Obviously, none of us just know it, like the back of our hand, even if we've done this frequently. And like just going through laws is not usually the easiest reading. It's usually pretty cumbersome. It's very complicated and confusing oftentimes. So trying your best to do things like this, taking these types of trainings can certainly be helpful. But if you don't know the aspect of the law, seek legal counsel counsel that does. Seek somebody who can give you the legal answer because that's always going to be your best practice. Be consistent. So always universally applying policies, making sure understanding why you're doing so. Not only will being consistent hopefully prevent any sort of treatment different based on a protected category, but in addition to that, you will certainly notice if something is not going kind of according to plan or according to norm. You will notice if there's differences in what's happening when you've always been very consistent in a practice. Train your managers and employees, especially the individuals that are having any issues with the general public or talking to the general public, making sure they know what to say and not to say. Those discriminatory statements pieces, a lot of those come out just in an employee, maybe in passing or talking to somebody who called in on the phone. They certainly can cause some problems if they're not aware of what they should be watching for. Document everything. If everybody documented as much as they possibly could, it would make our job so much easier. It's the day and age where everything is so easily documented. You can have text messages, you can have, memos, you can have even phone calls, voicemails. Those can be transcribed easily. So really having documentation is going to be very helpful. And then lastly, be nice. We do not get a lot of complainants that come to our office that are thrilled about all of the experiences they had, but they just feel like they should file. Usually we get people who are very upset. They feel that they've been wronged. They feel that something has occurred that shouldn't have. It's not that being nice is going to prevent all issues from occurring, but it certainly can kind of help set up things so that the tenants understand exactly what it is, why the decision was being made. But additionally, it also helps to kind of try to smooth things over occasionally that may stem into bigger issues down the line. So that's all I had for you guys. Any questions?
I don't see any in the chat right now, but we'll give it a couple minutes. Anyone have any questions or comments, feedback? Just make sure there's no. All right. Well, thank you, Kirsten, for presenting today. Thank you, everyone, for attending today's session. Next week, Kirsten's coming back and presenting on the fair housing that was rescheduled from last week. So we will look forward to that. That will be a 2-hour session. So for those of you that are planning on coming next week, just make note it's a 2-hour session. Again, be on the lookout for the survey that will be sent out here, and please provide any comments, concerns, feedback, topics that you'd like to see presented on. We have a couple openings for this session, and then I will start planning the spring session of training. So any of that is welcomed. So hope everybody has a good rest of the day and happy Halloween.
Thanks, Kylie.
Okay.